If you've just been in a car crash in New York, I need you to hear this because the insurance companies already have a plan and it's not in your favor. They're counting on you to panic, to stay quiet, and above all, to never ask the 5 questions I'm about to give you. Because the moment you do, you take control of the claim, uncover hidden benefits, and potentially unlock tens of thousands of dollars they'd rather keep. But here's the catch. You only get one shot. Once you settle or miss a deadline, you're locked out for good. These questions aren't just helpful. They're the time-sensitive leverage in a system designed to confuse you. If you skip this, you're playing their game. Ask them and you flip the board. I'm Brett Harrison, a New York injury attorney, and I'm here to tell you that insurance companies in New York train their adjusters to minimize payouts and protect their bottom line. They hope you never ask certain questions after a car crash because the answers could expose your rights and potentially cost them money. Today, as an experienced New York personal injury attorney, I'm going to reveal 5 questions that insurance companies fear you'll ask. Knowing these will give you the upper hand when dealing with accident claims under New York's no-fault law and beyond. Let's dive right in. Question 1. How much insurance coverage is available to cover my injuries and losses? This is one of the first questions I tell accident victims to ask. Insurers dread it because once you know how much coverage is available, you can aim for the maximum compensation. In New York, drivers must carry a minimum amount of liability insurance. For example, $25,000 for one person's injuries. But how many carry limits or have higher umbrella policies? The adjuster likely won't volunteer their insured's policy limits, especially if those limits are high. In fact, New York law requires the insurer to disclose the policy limit if your attorney requests it in writing. Knowing that number sets the ceiling on your claim. If you find out the at-fault driver has, say, a $100,000 policy, you'll insist on full compensation rather than settling for a lowball offer. Practical advice: have your attorney send a written request for the at-fault driver's coverage information. By law, the insurer must respond, often within 45 days, with the policy limit. Once you have that information, you can plan accordingly. Don't accept any settlement or sign anything until you know how much insurance money is on the table. Question 2. What no-fault benefits can I receive and what deadlines apply? New York is a no-fault state for car accidents. This means your own insurance, personal injury protection, or PIP, will cover your medical bills and lost wages up to a limit, usually $50,000 per person, no matter who was at fault. But insurance companies hope you aren't aware of all the benefits you could claim or the strict deadlines to claim them. If you miss a deadline or overlook a benefit, they save money. Right after an accident, you must file a no-fault claim or an NF2 form with the insurance of the vehicle you occupied. In New York, you generally have 30 days from the accident to do this. If you don't file in time, the insurer can deny your no-fault benefits entirely. PIP benefits typically cover your necessary medical expenses plus 80% of your lost earnings, up to a monthly cap of around $2,000. And even certain out-of-pocket costs, like travel to doctor's appointments, up to $25 a day. The adjuster isn't going to remind you of all these. Every dollar you don't claim is money they keep. So they fear the informed questions like, what exactly can I get under no fault? Practical advice: file your no fault application within 30 days of the crash. Submit all your required documentation for your medical bills, lost wages, and other expenses promptly. There are strict time windows for these. Don't be shy. Ask the adjuster specifically if an expense is covered. You could be reimbursed for prescriptions, physical therapy, or even help with household chores while you're injured, but only if you claim it and meet the timeline. Using your no-fault benefits gets your basic expenses paid now so you can focus on recovery. And remember, using PIP won't raise your premiums or count against you. It's coverage you paid for. It's your right to use it. Question 3. Do my injuries meet New York Injury's serious threshold so I can sue the at-fault driver for pain and suffering? Under New York's no-fault law, you generally cannot sue an at-fault driver for pain and suffering unless your injuries are deemed serious, Insurance companies fear this question because if the answer is yes, you can seek a far greater amount of compensation from the at-fault party's insurer. New York law defines serious injury with specific categories. For example, any broken bone is considered serious, as is significant disfigurement, like a very prominent scar, or a permanent or long-term limitation of use of a body part. Even injuries that temporarily prevent you from performing your usual daily activities for a substantial time can qualify. If your injury falls into one of these categories, you can step outside the no-fault system and file a lawsuit for damages. That means you can demand compensation for pain and suffering, not just medical bills. Insurance adjusters definitely don't want you to realize your injury is serious. If you have a qualifying injury, their exposure jumps from a few thousand in no-fault benefits to possibly the full policy limit or more in a lawsuit. They might downplay your injuries or wrongly tell you that you can't sue because of no fault. Don't take their word for it. If you suspect your injuries are more than minor, this threshold question is crucial to explore. Some practical advice: have a qualified personal injury lawyer review your medical record. For example, if an x-ray shows a fracture, that alone meets the threshold. If your injuries are less obvious, like soft tissue damage, document how they affect your work and daily life. An attorney can tell you if you meet the serious injury criteria. If you do, they can pursue a lawsuit or threaten one. Strong leverage to get the insurer to pay a fair settlement for your pain, suffering, and other non-economic losses that no fault doesn't cover. Question 4. What if the other driver has little or no insurance? Can I still be compensated fully? This is a situation many people don't think about until it happens. Say you're badly hurt, but the at-fault driver only has New York's minimum insurance or none at all. The minimum required liability coverage, $25,000 per person, might not come close to covering your losses. Insurance companies hope you'll just accept that limited amount. They fear you'll ask if there are other ways to get fully paid. Fortunately, New Yorkers can have extra protection called supplemental uninsured or underinsured motorist SUM coverage on their own policy. SUM lets you claim from your own insurer if the at-fault driver's insurance isn't enough. In fact, policies issued in recent years automatically include SUM equal to your liability limits unless you opted out. For example, if you carry $100,000 in liability coverage, you likely have $100,000 in SUM coverage too. So, if the driver who hit you only has $25,000 of coverage, your SUM could provide an additional $75,000 to make up the difference. Of course, no insurance company will volunteer this information. Neither the at-fault driver's insurer nor your own will be quick to mention SUM because that means they have to pay more. That is why having a lawyer helps. An experienced attorney will investigate all possible coverage. For instance, if the at-fault driver was working or driving a company rental vehicle, an employer's or a rental company's insurance might also cover the accident. Uncovering these sources can be the key to getting fully compensated. Practical advice: if you suspect the other driver's insurance is insufficient, notify your own insurer promptly that you may need to file an underinsured motorist claim. Many policies require timely notice for SUM claims. Review your oral policy with your attorney's help, if needed, to understand your SUM coverage. Always ask for the at-fault driver's insurance details and limits, as mentioned in question 1. Don't assume you're out of luck just because their coverage is low. A lawyer can help track down and pursue additional sources of compensation so you're not left footing the bill due to the other driver's lack of insurance. Question 5. Should I talk to a lawyer before I deal with the insurance company or accept a settlement offer? From an insurance company's perspective, this might be the scariest question of all. Adjusters know that when you have a skilled personal injury attorney, their usual tricks to minimize your claim won't work as well. The insurer's goal is to pay as little as possible, whereas a lawyer's job is to get you everything you deserve. They definitely don't want you to have an informed advocate on your side. It's very common after a crash for an insurance adjuster to reach out to you right away, sounding friendly and concerned. They might suggest, "You don't need a lawyer. offer a quick payout if you just sign some paperwork or ask for a recorded statement. Be careful. These moves are often meant to get you to say or do something that hurts your case or to settle for cheap. If you directly ask an adjuster whether you should get a lawyer, they'll almost always say no. That in itself tells you how much they fear getting legal help. Here's the reality. You have every right to consult an attorney before speaking in depth with any insurance company or signing away your rights. In fact, you absolutely should. In New York, most personal injury lawyers offer free consultations and work on contingency, so it costs you nothing up front to get expert advice. Having a lawyer early means you won't accidentally say something or sign something that sabotages your claim. For example, you are not required to give the other side a recorded statement, and you should never sign a release or settlement agreement without having it reviewed. Once you settle and sign, you can't go back for more. So, you need to get it right the first time. Practical advice: always talk to a qualified injury attorney before making any big decisions on your claim. If an adjuster calls with questions or a settlement offer, politely tell them you'll be consulting your lawyer. Don't let anyone rush you or pressure you into take it or leave it deals. A good attorney will handle communication, protect your rights, and fight for the real value of your case. People who get legal guidance tend to recover a lot more. No wonder insurance companies hope you won't. So yes, make that call and get the advice you need before you agree to any settlement or give any recorded statement. To sum it all up, asking these 5 questions will help level the playing field after a New York car accident. They compel the insurance company to play fair by revealing all coverage, paying the benefits you're entitled to, acknowledging serious injuries, uncovering every source of compensation, and respecting your right to counsel. Remember, knowledge is power. Don't be afraid to ask these questions and demand answers. An informed accident victim is the insurance company's worst nightmare and your best chance at getting the compensation and justice you truly deserve. You now know how to challenge the insurance system after a crash. But what if the tables turn and you're the one at fault? In New York, being at fault doesn't just mean higher premiums. It could expose you to lawsuits, out-of-pocket expenses, and even criminal charges. Don't leave your fate to chance. Click here to watch what happens if I'm at fault for a New York car accident. This next video breaks down your rights, responsibilities, and the critical steps you must take immediately to protect yourself through this challenging situation.